Hello everyone, this is Tom Fox and I'd like to welcome you to episode 207 of the FCPA Compliance and Ethics Report. Today I have back with me Mara Senn. Mara is a partner at Arnold & Porter in Washington. She is a white-collar practitioner and works in the FCPA space. Mara is going to visit with us today about negotiating a FCPA settlement with the Department of Justice and the Securities and Exchange Commission. She's going to walk us through how you negotiate the penalty phase and the facts which go into a settlement document, whether that be a DPA, NPA, or a civil side on the Securities and Exchange Commission. The episode comes in at just over 24 minutes. I hope you will enjoy it. Thank you very much for listening. Hello, everyone. This is Tom Fox. I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. I'm extraordinarily pleased to have back with me Mara Senn. Mara is a partner at Arnold & Porter. She is a white-collar practitioner extraordinaire and a FCPA Guru S, or at least that's what I call her. Anyway, she has writes extensively on the FCPA. I've been lucky enough to visit with her a couple of times, and she has certainly informed a lot of the thinking that I have brought to the table in terms of working with the government, negotiating with the government, on FCPA enforcement action. So, Mara, with that, welcome and thanks a lot for coming back.
Thanks so much for having me again, Tom.
Mara, what I wanted to visit with you today was to maybe follow up in a little more detail with some of the things you talked about in prior podcasts in terms of helping companies through an FCPA enforcement action. What happens when you sit across the table from either the Department of Justice lawyers or lawyers at the Securities and Exchange Commission? So I thought maybe you might help us understand that process, because many civil litigators have never gone through that, and certainly people even like myself who work on the nuts and bolts side of things haven't gone through that process. And I know you have, both in the FCPA world and in the wider white-collar defense practice you have as well.
Sure. So it's really a process. It evolves over time. I mean, you're involved in an investigation and you form relationships with the prosecutors. There's really, from the government side, there's not really any formal policy about resolutions in terms of, the way that it should work or that it has to work. And really, it's to a certain extent, it very much varies from case to case, depending on the facts and other elements. But there are a few things that I think you can sort of say overall. One thing that I have found is that if you are in a multi-jurisdictional case, which happens most often in FCPA cases, so there are other prosecutors from other countries who are part of the negotiation, in those instances, there's a lot less flexibility because everybody needs to come to consensus. So if you change one thing, everybody has to agree with it, sign off on it. So in general, regulators tend to be less flexible in those situations because usually it's in the company's best interest to have that drop all at once. They don't want to say we settled with the U.S. and then 2 months later we settled with Germany and then 2 months later we settled with, another country, because that really creates multiple news cycles, which is the exact opposite of what you want. You're going to as a company, you're going to have a big splash, but you want it to be as small as possible, and you don't want it to be, you don't want the story to drag out and out and out. So as a company, your interest is really more in getting it resolved in a global way than nitpicking about the specifics of the language. And quite honestly, the government is going to give you and have less flexibility in terms of changing things around. As with so that's one thing, is what is the context of your case, and are there multiple, and this is true also with multiple actors within the U.S. So if there's the SEC and DOJ and HHS, for example, again, the more players there are, just the more complicated it gets to do revisions and the less flexibility you're going to have. But as with all things having to do with this world, your relationship with the prosecutor is very important. If there are no external factors that prevent flexibility, if you have a very good cooperative relationship with the prosecutor, you're going to get more flexibility at the end of the process. If you have a very antagonistic, antagonistic doesn't mean that you have to agree with them on every single thing, but typically, you have a relationship where the prosecutor thinks you've been reasonable, you think the prosecutor has been reasonable, and you've been able to come to an agreement on where you're both coming from. That is, works just as well as somebody who just panders to the government at all times. So, but if it hasn't gone smoothly, then you're just going to have less flexibility in that negotiation stage, because really at the end of the process, leading up to it, you're doing the investigations, you're giving them documents, you're giving them access to employees often, you're presenting facts to them, you're making advocacy arguments, but in the end, whatever ends up on the paper and as part of the deal, that's really where the most advocacy comes into play, because that's really where the rubber hits the road and your company has to take a plea or pay some fines. The other thing is that I found that the flexibility also depends on other terms of the resolution. So if you're getting an incredibly good deal and you know it and the prosecutor knows it, you're going to get less give on the language because they already think you're getting a lot. So really, those are some of the things that I think affect it. The other thing to keep in mind is if your settlement is above $200 million, the Deputy Attorney General has to approve the settlement, and that means in a regular case under $200 million, you can probably, the line prosecutor is going to negotiate with you, maybe their supervisor, and so there's one or two levels of review. Maybe the chief of the unit will sign off on it as well. But if it's over $200 million, there are going to be multiple levels. The Deputy Assistant Attorney General, the Assistant Attorney General for Criminal, and then eventually it'll make its way up to the DAG. So there could be 3 or 4 extra layers above that. So that, I think, tends to make prosecutors a little bit more conservative, because their boss and their boss's boss and their boss's boss's boss and on up are going to be reviewing it. So it has to be something that's palatable to all layers of the government on a variety of different things. So that's really that's really my take on those sorts of negotiations.
Mara, let me see if I could maybe dive into a couple of those points. When I look at a resolution of an FCPA case, whether it's an SEC, cease and desist order, agreed civil complaint or other, or a DOJ, DPA or NPA, I generally see two things in a settlement document, or what I would call a settlement document. I see some agreed facts, and then I see some agreed penalty, I guess 3 things, and some agreed resolution going forward. The agreed resolution going forward in a DPA form is usually the Schedule C, best practices compliance program, and then any additional or supplemental terms that the parties have agreed to. And then penalty is generally in DOJ documents based on the sentencing guidelines in some form, with some additions or subtractions based upon conduct, cooperation, and other factors, and then the agreed upon statement of facts. So if I could maybe focus on the penalty phase of the negotiation, over the past certainly 18 months, specifically with Parker Drilling and HB, we saw penalties at a level below the minimum of the suggested range of the sentencing guidelines, and the Department of Justice, at least in their press releases, said it was due to the both cooperation of the parties, or rather the defendants, and the cooperation, the efforts at remediation during the pendency of the enforcement action. Are those things that an advocate such as yourself can use in a negotiation with the Department of Justice? And if so, how?
Oh, absolutely. I mean, so for example, in terms of cooperation, if your company has provided a lot of documents, if they've provided key documents that the government otherwise would not have found or would have found it harder to find, or have, put facts together that make their lives a lot easier, which is what we do a lot. And importantly, made it less of a hassle for them to interview witnesses. So, for example, a lot of these cases, they will have the U.S. will have no jurisdiction over witnesses. And so as a gesture of good faith and cooperation, companies will actually fly their witnesses in from other countries so that they can be interviewed here. Now, typically, you do that when your individual employees don't have individual liability because, usually those are more the fact witnesses, but that is considered helpful cooperation. So obviously you put all of that together. And then remediation, let's say that, as in so many of these cases, that the problem was that they didn't detect a bad third party or a bad actor third party because their third party screening was weak. And you can come forward as a company and say, okay, we've instituted everything. Everything's on the computer now. You absolutely cannot, it cannot go through the accounting software to open up a new vendor unless you have these sign-offs from, senior people or people who are really embedded in this program and can show that that's really that if that system had been in place, it would have prevented the problem in the case at issue, then that can be pretty powerful. The other thing about sentencing guidelines is there are certain amounts of input, for example, amount of loss, and that is based on the profit of the given contract or the given transaction. That can often be very movable. So, for example, if you have an investigation in Egypt, but there also was some investigation in China, one thing you can negotiate and say is, well, we're only having a resolution as to Egypt, so let's not count in the total amount of loss anything from China because that's not part of what we're resolving here. Now, they may or may not go for that, but there are a lot of different ways to slice and dice, even within the sentencing guidelines. And then there have been instances, where the government just has their math wrong, and so you can definitely correct inaccuracies in that way as well. But one thing to remember is that the amount of loss is really a number that completely depends on what you define as being in and what you define as being out. And so in some cases, it's possible that, right now the government is having a problem encouraging companies to self-disclose because most companies don't think that it's in their interest. And then with the Yates memo now, it's probably going to be even harder for them to convince companies to self-disclose. And if you're in a position where you're negotiating with the government, you want to make sure that you're getting the best deal you can based on the facts that are before you. And a lot of these press releases and characterizations and language that the DOJ uses is often to encourage people to cooperate and to remediate because once they're in there, the DOJ has control over the process to a large extent, and they want to send the message to companies, we will reward you for cooperation and remediation. Query whether that reward is sufficient to overcome the disincentives to self-disclosure, but that's basically, I think, what's going on in a lot of these cases is that it's possible to deflate or inflate the sentencing guidelines calculation, and I have no idea, the underlying reality in any of the recent cases, but I do know that it's possible to make the sentencing guidelines look worse, give a better deal, and then say, oh, look, we gave you credit for cooperating and remediating. And again, I'm not saying that is what happened here, but it is possible for those numbers to be changed as part of the negotiation.
To come up with a number to start with, you have to agree upon what goes into it, it sounds like.
That's right. And often it's not, you're not agreeing. They're coming to you and saying, this is our calculation, and then you push back. It's not like they don't necessarily say to you, what do you think? But usually you have a calculation that you've done, and different areas that you can try to peel off or ways to whittle down the loss.
so that even if there's cooperation between the parties, there still can be adversarial arguments by someone like yourself representing the company with someone, a lawyer from the government representing the DOJ over what should be the proper starting point.
Oh, absolutely. Because, I mean, remember, as we've seen in some recent cases, an investigation could start in one country and move to another country because they've discovered additional facts. They could find out that the initial country, there wasn't much going on there. But the government might say, well, we investigated you in 5 different countries. We want to put all that in. And the company could say, well, wait a second. You didn't have there were no findings in this country or that country or that country. So we don't agree to, we can't plead guilty for, or come to a resolution for those other countries because it's our position, as you yourself as founder, have indicated to us that there's nothing going on in those countries, so we don't want that to be part of the resolution, and similarly, we don't want it to be part of the sentencing guideline calculations.
Mara, now if I could move to the other component of what I see in the resolution documents, which are the statement of facts, the agreed statement of facts, the admissions of facts occasionally, or the non-contested statement of facts, whichever might be the appropriate phrase. And I want to introduce that with, once these documents are made public, they're public for all purposes, and that could be for PR purposes, that could be for reputational damage purposes, it could be for shareholder derivative litigation, it could be for litigation between private parties going forward. So once it's out there, it's out there, and you hinted at companies wanting to make as small a ripple as possible. How would you go about thinking through advising a company or sitting down with your adversary across the table and to negotiate the agreed upon facts?
Sure. I mean, first of all, civil litigation is really one of the biggest concerns of any company because they can negotiate, agree upon a settlement with the government, they pay it, and then at least monetarily it's over. Obviously, civil litigation can go on and on and on, and there's, except for when the statute of limitations has run, there's really no limit as to the degree of liability, and just the transactional cost of litigation can be huge. So, a big, huge concern of companies is civil litigation. Well, that is not at all a concern but on the DOJ side, they don't care. I mean, that's not at all their area of concern. So I found that if you say, well, we have civil litigation risks, that really doesn't go far with the DOJ. They really don't give any weight to that.
Okay.
But that being said, you can strategically, you don't have to, not that you're hiding from the DOJ, it's more that the DOJ really doesn't care. I mean, you can strategically try to change the language to minimize, looking at it from a civil litigation perspective. So instead of saying, admits or concedes, try to have a less, sometimes you can, sometimes you can't do that, but, rather basically just have them, try to make them set forth the facts and not characterize them. So instead of saying, he stealthily, took the money and hid it in his blah, 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 instead saying, Jack Smith loaded up a suitcase full of cash and flew from X to X and delivered that money to this person, as opposed to, characterizing it in such a way that makes it look worse. The other thing is that I think works well is to try to, once you get a draft of the DPA or NPA, is try to not niggle every single word, and also not to have too many back and forths with DOJ, because usually they have to get some kind of sign-off if they change language, and it's annoying and embarrassing for the line attorney to constantly be going back and forth like, here's another draft, here's another draft. So really pick your battles, decide, okay, this is really our weak spot when it comes to civil litigation or whatever your other concerns are. This is where we would like to go to the mat, and here's, our comprehensive sort of revisions that we'd like to see implemented. And rather than, I wouldn't think of it as a contract negotiation where you're, you're changing this section and you're changing that section, and then, because that section changed, now we have to go back and do another section. There are transactional costs on the government side because they're constantly going back to their supervisors, and to allow and you can say to this prosecutor, if you just like you would in any any negotiation, hey, look, the following three things are what we really, really care about. If you can get those, I think my client, will not care as much if you can't get X, Y, and Z, so that they know when they go to their supervisors, they have a sense of what your priorities are. And, of course, sometimes the line prosecutor's like, well, you know what, that's just a no-go. I can tell you right now that's never going to happen. And then you can say, okay, fine, well, that's not my priority anymore. How about this one? So, but you want to sort of think about what the back-end process is for the prosecutor and make their life easier not mainly because it will allow you to get more of what you want in your negotiations.
So that's really a great insight. No one talks about the transactional cost on the government side of negotiations, so it's a really, really interesting insight to bring to the table. I wanted to talk to you about the Yates memo, but unfortunately, I'm afraid we would probably double our time. So maybe we could save that for an entire separate episode, because I really just want to explore that, or at least get your thoughts on that as well. So with that, Mara, if someone wanted to follow up with you on any of the things that you talk about or get in contact with you, could they email you? And if so, how would they do it?
Yeah, they sure could. It's at mara.senn at aporter.com. And if you Google me, Mara Senn, MARASENN, you'll be able to find my bio on the Arnold & Porter website, and you can reach out for me there too.
Well, Mara, I really appreciate you talking to us again today. Every time I visit with you, I just gain so much more insights into the craft of being a white-collar and FCPA defense lawyer, as opposed to being able to spell it and say I'm one. So thanks a lot for taking the time to visit with me, and I look forward to visiting with you about the Yates memo.
Okay, great. Thanks so much, Tom. Talk to you soon.
Right.
Bye.
Hello everyone, this is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance and Ethics Report. I have two calls to action for you today. The first one is to please go to iTunes and rate this podcast. The second is I'm developing a list of questions for my next mailbag episode. So if you have any questions, I would appreciate it if you could email them to me at tfox@tfoxlaw.com. I hope you've enjoyed this episode, and you'll come back for next episode, which will be this coming Thursday. Thank you very much for listening.